Until August 2024, falsely writing the letter R in a circle next to an unregistered trademark could lead to a prison sentence. Today, that same act is met with a monetary penalty. This change was introduced by the Jan Vishwas Act, a piece of legislation that overhauled the penalty structure of the Trademarks Act and serves as a major focus for current affairs questions in the 2027 exam. In this lecture, we will analyze the procedural shift of appeals to the High Court, the definitions of criminal offenses, the specific safeguards for search and seizure, and the impact of the two most recent amendments. On the 2027 exam, candidates are expected to distinguish between technical marking errors and intentional economic fraud. Misidentifying a civil infraction as a criminal offense remains one of the most frequent causes for lost points in the enforcement chapter. We begin with two foundational legislative shifts. First, the Tribunals Reforms Act of 2021. This abolished the Intellectual Property Appellate Board, or IPAB, and transferred its entire jurisdiction, including appeals and rectifications, to the high courts. This creates a definitive rule for your answers. For any question involving procedural actions after April 2021, the IPAB no longer exists as a valid forum. The answer is now exclusively the High Court. The second major shift comes from the Jan Vishwas Act of 2023, which became effective on August 1, 2024. This legislation targeted minor and technical offenses for decriminalization. Under the amended Section 107, falsely representing a mark as registered no longer carries a prison sentence. It is now a civil penalty, either 0.5% of annual turnover or 5 lakh rupees, whichever is the lower amount. Furthermore, Sections 108 and 109, which previously penalized false descriptions of a place of business and registered falsification, have been entirely removed from the Act. To manage these civil complaints, the 2024 draft amendment rules introduce a specific filing mechanism, Form TMD, to be adjudicated by a departmentally appointed officer. These changes mean that technical marking errors are now handled as civil infractions, while intentional counterfeiting remains under the jurisdiction of the criminal courts. Section 91 governs the path for appeals. If a person is aggrieved by a registrar's decision, they have the statutory right to bring that matter before the High Court. The limitation period is exactly 3 months from the date the order is communicated. While the High Court can condone a delay, the applicant must demonstrate sufficient cause for missing the deadline. This appellate route applies to most registrar actions, including the refusal of an application, the outcome of an opposition, or a decision regarding a renewal or rectification. Appeals are typically filed in the High Court that holds jurisdiction over the specific registry office involved, namely Mumbai, Delhi, Kolkata, Chennai, or Ahmedabad. The registrar is entitled to be heard during these proceedings, particularly on points of law. However, the registrar cannot be ordered to pay costs, nor are they entitled to receive them. To remember this timeline, note the symmetry with geographical indications. Both trademark and GI appeals utilize the same 3-month window. Since the IPAB's dissolution, the High Court is the primary forum for challenging any administrative decision made by the registry. Turning to criminal liability, Section 102 establishes the 2 core offenses. Falsifying a mark involves creating a deceptively similar mark without assent. Falsely applying involves using a mark on goods, services, or packaging without the owner's permission. Practically, a printer who produces fake labels is falsifying the mark. The manufacturer who attaches those labels to non-genuine products is falsely applying it. In these prosecutions, the burden of proof regarding the proprietor's assent rests entirely on the accused. Sections 103 and 104 set mandatory penalties for these acts. A conviction carries a prison term of 6 months to 3 years and a fine between 50,000 and 2 lakh rupees. Under Section 105, a second or subsequent conviction increases the severity. The minimum imprisonment rises to 1 year, and the minimum fine doubles to 1 lakh rupees. A court may only sentence below these minimums if they explicitly record adequate and special reasons within the written judgment. These penalty structures match those found in Sections 39 through 41 of the GI Act. Memorizing this set of numbers covers both areas of your syllabus. Because these sections address intentional economic fraud rather than technical marking errors, the law maintains mandatory imprisonment as a primary deterrent. Section 115 classifies these offenses as cognizable, meaning police can investigate and seize goods. However, the Act imposes two significant procedural safeguards to control this power. First, no officer below the rank of Deputy Superintendent of Police, or DSP, is authorized to conduct a search and seizure under this section. Second, the officer is required by law to obtain the opinion of the registrar on the facts of the case before proceeding, and they must abide by that opinion. If goods are seized, any party with an interest in them has a 15-day window to apply to a first-class magistrate for their restoration. Section 114 extends liability to companies. While the entity itself is liable, the individual in charge is also personally responsible, unless they can prove the offense happened without their knowledge or despite their due diligence. You can remember the search requirements with the acronym DROP, representing a DSP rank officer plus the registrar's opinion prior to the search. These hurdles ensure that police enforcement is directed at criminal counterfeiting, rather than being used as a tactical tool in routine brand disputes. We return now to Section 107, which prohibits falsely representing a mark as registered. This includes the improper use of the word registered or the R in a circle symbol for a mark that has not yet completed the registration process. There is a statutory exception for marks registered abroad, if the mark is genuinely registered in a foreign country and the usage makes that context clear. It does not violate this section. Following the 2024 changes, the penalty for this violation is purely civil. It is calculated as 0.5% of annual turnover, but it is capped at a maximum of 5 lakh rupees. For your exam preparation, remember that the TM symbol is the correct designation for unregistered claims, while the R symbol may only be used after the registration certificate is officially issued. The whichever is less cap on the fine ensures that technical marking errors do not result in disproportionate financial penalties for high-turnover companies. Criminal prosecution and civil suits run on independent parallel tracks. On the criminal track, the state pursues Sections 103 through 105 for fines and imprisonment. Simultaneously, on the civil track, the proprietor files under Section 29 for injunctions and damages. A brand owner can pursue both routes at once, utilizing the criminal system to stop counterfeiters while using the civil system to recover financial losses. Question 1. Where are TM appeals filed? High Court, within 3 months, and condonable. Question 2. When did the Jan Vishwas Act changes take effect? 1st August 2024. Question 3. What is the new penalty under Section 107? A civil fine of 0.5% of turnover, or 5 lakh rupees. Question 4. Which sections were entirely omitted? Sections 108 and 109. Question 5. What is the penalty range for Sections 103 and 104? 6 months to 3 years, plus 50,000 to 2 lakh rupees. Question 6. What is the enhanced penalty for a repeat offense? 1 to 3 years, and 1 to 2 lakhs. Question 7. What are the 2 requirements for a search under Section 115? DSP rank and the mandatory opinion of the registrar. Question 8. Who must prove the proprietor's assent in a counterfeiting case? The accused. Accuracy in these specific procedural figures and penalty caps is the requirement for a professional score. In the next lecture, we'll move to the global stage with the Madrid Protocol and Section 154. I'll see you there.